All right, well, welcome to another OSHA Quick Take with Conn, Maciel, Carey. I'm Scott Cuthbert, CEO of Safepedia. It's my great privilege and to have the gang from Conn, Maciel, Carey with us today. And today we're going to be talking about the latest on rulemaking agenda for OSHA under the Biden administration. So as we move into the second half of the Biden's first term, OSHA is turning up the heat on the rulemaking gears, and the next 2 years may be the most active rulemaking period in the agency's history, with lead, heat, infectious disease, lockout, tagout, PSM, E-Recordkeeping, HAZCOM, COVID for healthcare, and the list goes on. So we've got the crew today who are going to address this. They're going to have the full webinar on May 18th, but we wanted to give you a kind of a quick take on what that webinar will be about. So I will we'll turn it over to maybe Kate. You can kick it off, introduce yourself. We'll go around the horn, and then we'll jump into today's OSHA Quick Take.
All right. Well, thank you very much, Scott. On behalf of Lindsay, Beeta, and our entire law firm, I want to just thank you for inviting us. We're very, very happy to work with you to hopefully provide some education to your viewers on this month on OSHA's rulemaking process and where their focus is, what we expect to see over the next couple of years under this President Biden's first term, and generally, the priorities that OSHA has set for the agency, and we'll probably get a little bit also into some state rulemakings of significance, but we'll mainly remain focused on the federal rulemaking process. I think that let me turn it over to Lindsay and Beeta to share what you have to share about what we want to talk about during the webinar.
Thanks, Kate. My name is Lindsay DiSalvo, and I work with Kate and Beeta at Conn, Maciel, Carey as a partner in both the safety and health and the labor and employment practices. And a big part of, I think all three of us do a significant amount of work on rulemaking. Our firm has participated in several of the rulemaking process over the last several years, lots of years. All of us sort of having our specialty in that regard. Kate particularly, I think, is our real guru on rulemaking. She's definitely been a part of this process even before coming to Conn, Maciel, Carey. So we have some pretty extensive experience here and look forward to sharing, at least some of that today, as well as during our webinar in a couple of weeks. Beeta, I'll kick it over to you.
Sure. So I think Kate and Lindsay covered it pretty well already substantively, so I'll just introduce myself really quick. My name is Beeta Lashkari. I'm an associate at Conn, Maciel, Carey from the DC office, and I work in the workplace safety practice group.
Great, and Beeta, you're new to the OSHA Quick Take, so we're gonna put you on the hot seat to start with, and you're gonna kind of take us through what the OSHA rulemaking process is. Or how it works.
Would that be okay, Scott, if Kate takes that one?
Did I?
Sort of the process through, yeah.
Sorry, I got it backwards.
No worries. Beeta actually lives this. We're living a couple of rules right now on behalf of a number of our clients, so she knows it. But let me at least give an overview. I have, as Lindsay mentioned, I have been involved in I guess I would say most, if not all, of OSHA's significant chemical rulemakings over the last couple of decades. My first major involvement was with HAZCOM. I think the HAZCOM rule was promulgated in final form in 2006. So that's some time ago. And for years in advance of the final rule, of course, I worked on behalf of industry stakeholders with OSHA, I think in a very constructive fashion to provide information, data, and the support they needed for OSHA to ultimately develop a rule that remained in place even after some legal challenges. The rulemaking process itself is a long and arduous road that the agency has to follow. Some of that road has been paved because there is case law precedent around what you do have to do during the rulemaking process. The APA, the Administrative Procedures Act, of course, impacts the OSHA Act, and those two work together to sort of define what the rulemaking process looks like for OSHA. There's also internal procedures that OSHA has set up its own guardrails to make sure that it develops the best rule that it can make. And then there's pressure from outside stakeholders, both worker advocates and public health advocates, as well as industry advocates, to press OSHA in each individual rulemaking process to look at certain information and data and analyses. The GAO issued a study in 2012, so a little bit over a decade ago, that indicated, I think, Beeta is 7 years for OSHA to promulgate a standard. So it takes a long time, and 7 years is on average what it takes. But with chemical rulemakings, just to FYI, because that's a particular focus of mine, it takes even longer than that. So it's a long step. And just basically, because we don't have all day, and we'll go into this more in depth at the, during the actual webinar itself. But there are numerous stages. We would sort of describe 7 stages of rulemaking. Some of these stages are not seen, they're not really visible to the public. And one thing that I know from practicing in this area for so long is those early stages, which are really not even fully visible or transparent to stakeholders, are actually a time when OSHA is really learning there's always a hazard. That's why OSHA is promulgating a rule, right? There's a hazard they've identified. OSHA is really learning about the hazard, studying it, and very open to hearing what industry and labor advocates have to say about that. It's a very formative, very rudimentary stage. OSHA is developing the risk analyses, the technological and economic feasibility analyses that will drive where the rule ultimately ends up. So it really makes sense to get involved early in the rulemaking process. I think I often will joke, kind of like voting, early and often, right? And get involved early because you have so much more impact than in the later stages when everyone knows about it. But OSHA has, as the years pass, they get more and more set in what they think is the right path, and you have less and less ability to influence the direction of the rule. So this preliminary rulemaking activity, where OSHA actually does that initial research, meets with internal and external stakeholders, NIOSH is often involved in that. That's a good time to get involved. After that, OSHA is developing the proposed rule, not the final rule, but the proposed rule that ultimately will come out either as an advance notice of proposed rulemaking or a request for information, an RFI. And there's early opportunities to influence the rule. Those are all before what everyone knows about, which is a notice of proposed rulemaking, an NPRM, right? That's when everybody gets involved and the show gets bigger. Then public comment is submitted on those that NPRM, and OSHA then goes back to their room, figuratively speaking, and looks at those comments and hopefully studies them carefully and objectively, and then goes back to the drawing board and revises the studies and the risk assessments and the feasibility analysis, and then issues their final rule. In that process, based on executive order requirements and legal requirements, there's often with a significant rule that impacts small business, there's a SBREFA process that provides real opportunity for small business to get involved in the rulemaking process and provide its view and perspective on the impacts of this rule. And then there are often public meetings held. There's often an administrative hearing that is held on the rule. So anyway, bottom line is there are lots of moving parts, lots of pieces of OSHA's rulemaking process. OSHA has actually a very nice flow chart on its website, and I'm sure we'll have that as a slide in our presentation when we'll walk through that a bit. And then I guess the final thing is if the rule comes out a way that stakeholders don't like, Then there's post-rulemaking activity, and that comes in the form of legal challenges. Often OSHA gets sued sort of, quote, from both sides, if you will. And I know the agency kind of likes that, because if they're going to get sued, they'd rather not be sued, but if they're going to get sued, they'd rather have both sides saying, you know, this rule is not stringent enough and this rule is too stringent, because it makes it kind of easy to say to a court, I think we got it right, because these guys don't think it's good enough and these guys think it's too strong. So in any case, that's a, I don't know, 4-minute summary of the rulemaking process. Scott, I hope that's helpful.
Yeah, no, that's great. It's good to hear there's different opportunities for companies and public to get involved in reviewing and voting and maybe contributing to those future laws. I was just wondering, and if you might be addressing it in more detail on the 18th, but is it that onerous as well to undo laws that OSHA has brought into effect as well? So as administrations change, sometimes they undo the previous administration. So if something gets put in place, can we count on it being there for a while?
That's a really, really good question. And team, if it's okay, let me just take the first stab at responding to that question, Scott, because I think really important to understand, you know, when President Trump was inaugurated, one of the first executive orders that he issued was what was called the 2-for-1 executive order. And that was an executive order that basically informed not just OSHA, but all executive agencies that for every rule that it promulgates, it needs to get rid of 2 to make government smaller, right? Well, there's a little bit of a problem with that in that, as I think Secretary of Labor Scalia pointed out in a Wall Street Journal opinion piece, you can't just undo, if the administration changes and you don't like a rule, you can't just wipe it off the books. You have to, as the agency, follow the same process that has been put in place to put a rule, to develop a rule, promulgate a rule, to rescind a rule. Because in rescinding, you actually are changing the law, right? So you do have to follow certain procedures. Now, a lot of times those can go faster because you're not thinking about putting more impact and more obligation on industry, for instance. But you are thinking about taking protections away, arguably. And I think labor would have a lot to say about whether that would be allowed under the OSHA Act. So bottom line is, you can't just wave a magic wand and say, we don't like these rules anymore, let's take them off the books, take them out of the CFR. You have to follow the regulatory process, including the Administrative Procedures Act and what is in our world set out by Section 6 of the OSHA Act.
Great. So Beeta, we kind of touched on it a little bit in the intro, but I think you're going to walk us through what some of the priorities are for the current administration.
Yes, yep, that's right, Scott. So as Kate mentioned, and as you mentioned in the description, it's definitely been a busy season for OSHA on the rulemaking front, especially compared to the last administration. So I'll just start with a unique rulemaking in that it was promulgated as an emergency temporary standard, or what we call an ETS, and that's the COVID-19 ETS for healthcare. Not to say that this is sort of a top priority for the agency right now. It certainly was, but I just want to give a quick update since there is a lot of history and we get questions about this all the time about the status of the rule. And I definitely encourage, listeners to tune into our May 18th webinar to get more of the detail. But just for now, the proposed permanent rule is still pending review by the Office of Information and Regulatory Affairs, or as we call it, OIRA, within the White House's Office of Management and Budget. So this is despite the rule having been at OIRA for over 120 days, and that 120 days is important. What it reflects is 90 days is the original, is sort of the normal review period, plus 30 days, which OIRA gets as sort of an automatic one-time extension. So 90 plus 30 is 120. So that 120-day period lapsed on April 6th. So we're now in this post 120-day review period, and regulatory agencies do have this option to request an extension from OIRA. So we think that that's what's happened right now, is that OSHA has requested an extension of the OIRA review period. We did reach out to our OMB contacts to see if that request is made public, and we're told, no, but it's probably a safe assumption to make since we're past that 120 days. So that's just a quick update on, COVID-19. Getting into some of the more priority items for OSHA right now, let me start with heat. This would be a brand new federal rule, right? We don't have a heat illness and injury prevention rule. Certain state plans have had, heat illness prevention rules, a couple of which are more recent, like Oregon, which is, Oregon, I believe, is the first indoor and outdoor sort of combined rule. And that seems to be where we think, the route that federal OSHA is going as well, doing a combined indoor and outdoor heat rule. California has had their outdoor heat rule for a while now, and is really now picking up movement. They're really picking up on their indoor heat rule. So that's still in a proposal phase, but they are moving on that. I think things stalled with the pandemic a little bit, but we're seeing some movement again. But on the federal level, so OSHA did publish an advance notice of proposed rulemaking in AM PRM on October 27, 2021. And since that time, the National Advisory Committee for Occupational Safety and Health, or NACOSH, has been meeting, quite frequently, including a specific heat work group within NACOSH, so that they can possibly make recommendations to OSHA about, what a heat standard should look like. They also did, they also include, this subgroup on compliance materials. So really just taking a good, oversight and overview of, OSHA's sort of stance on heat and making some progress there. So that's just one thing we hear constantly is a top priority for OSHA is a heat rule. Another priority is changes to the E-Recordkeeping rule. This is in the final stages. It's been sort of a long and tortured history again. Maybe we'll get into more of that on May 18th. But basically, the rule was rejiggered to cover for the list of covered employers. There's a requirement to submit 300A data, so that list has been rejiggered. And then certain employers, the types of 300s that they have to submit, that's kind of going to be an additional requirement. So that's one to just look out for. It recently went to OMB for review, so it's looking like the near end stages. Lead is another top priority. This is in the pre-rule phase. Obviously, there already is a lead standard, so this would be changes to the lead standard. OSHA issued an ANPRM on June 28th, 2022. And is currently analyzing comments. And what's interesting about this one is that, it's really supposed to be geared towards looking at blood lead levels. There's, requirements for, certain, if you hit certain levels that employees would have to be taken out of the work area in sort of what's called medical removal protection. But the ANPRM, I will say, kind of does leave open the door to maybe changes to other areas of the lead standard, such as the permissible exposure limit, or PEL, and the action level, or AL. And interesting, a lot of states are moving on this too. So for example, California recently took comments, I think comments were due April 20th, about changes to its lead standard, including some really drastic changes to the PEL and AL, I think from 50 to 10 micrograms per meter cubed for the PEL, and 30 to 2 for the AL. So, a lot of activity going on at both the federal and state levels. And just wanted to incorporate, I know we did, we are going to be talking about state activity. So just wanted to weave some of that in there. There's also workplace violence for healthcare. That would be a new rule. It's in the pre-rule stage, and a request for information, or RFI, was issued December 7th, 2016. So it's been a long time coming for the agency. It just stalled a bit. but we're seeing some movement again. And the rule is what it sounds like. It would be a, workplace violence in healthcare and social assistance, where OSHA found sort of higher rates of workplace violence in those settings. And just to wrap it up, just a couple others: emergency response, changes to the emergency response standards. OSHA recognizes that it doesn't have sort of one comprehensive emergency response standard, and that there have been advancements in the emergency response community that it wants to, reflect in its standards. So that's one rulemaking. Another one is hazard communication, or HAZCOM. This one's interesting because, in 2012, it aligned with this globally harmonized system, which is sort of this living document. And when it did the 2012 rulemaking, that was in the third version of this GHS, which is now, much, it's, had many versions after that. And I think, right now they're thinking about updating the standard to reflect the 7th edition. So that's one part of the HAZCOM rulemaking. Another part is just incorporating a lot of letters of interpretations, enforcement guidance that has been issued, putting that right into the standard. So those are just some aspects of that rulemaking. So hopefully that gives a lot of top priorities, obviously, for the agency.
Yeah.
But good to see there's been a lot of movement, I say, on the rulemaking front.
Yeah, definitely sounds like the most active period for OSHA maybe in history, and I know from our interactions, there's a lot of support for the hate illness, but also a lot of concern that people don't know how to interpret it properly and implement it properly. So I imagine there'll be a lot of people on the 18th showing up to dive into a little more detail on that one, and I'm sure the other ones as well. So. And then Lindsay, you're going to take us through which rules we can expect the most activity on in the next few years here.
Yes, so I think Beeta covered quite a bit related to each of the rules, so I won't spend too much time. But just to reiterate, I think a big part of the webinar for us on the 18th will not only be sort of talking through where all of these are in the process, but the specific requirements of each, like what we really see as potentially problematic, what employers really need to kind of be aware of, on the lookout for. So sort of reviewing where these stand during the presentation today, we want to encourage people to join the webinar on the 18th because, today we're just kind of touching on the timelines of things, generally what people can expect, but it's important to really know the specifics. And one of the ones that I think will be the most essential to know the specifics for right now is e-record keeping, because that is the one that is on the horizon for OSHA promulgating a final rule. So OSHA actually sent that rule to the Office of Management and Budget, OMB, early in April. I believe it was April 7th, 2023. So that final version is currently under review. That's sort of the last step, going back to Kate's discussion on the rulemaking process. That's sort of the last step here before a final rule is promulgated. As part of that, the Office of Information and Regulatory Affairs, which is also referred to as OIRA, and as part of the OMB, is taking meetings with stakeholders. They're gathering some additional information, but what we foresee is that it's probably going to pass, and if not its current form, a very similar form to its current form. And though OSHA had originally set March 2023 as the point at which it would promulgate that rule, it looks like now, and I think OSHA is the current messaging, at least from OSHA now, is around June 2023. So this is one that is on the immediate horizon. Some of these we have a little bit longer for, but this one we can expect to come out in a final rule form at some point this summer, likely June 2023. A couple others that we've seen some movement on recently and expect to see some additional movement on in the next couple months are heat, which Beeta just touched on. But the next NACOSH meeting is on May 31st. So that's sort of another opportunity for NACOSH to collect information, to kind of give its own recommendations for what this rule should contain. And then in addition to that, an important part of the rulemaking process and sort of, I think the last step leading up to a notice of proposed rulemaking is what's called the SBREFA process, where small business is given the opportunity to sort of specifically get involved, specifically give their concerns related to the rule, have an opportunity for input to make sure that that's considered within the proposed rule that does eventually go out. And that is supposed to be starting this month, probably sometime really soon. So we can expect to see that SBREFA process start soon. And then from there, I mean, that can take some time still, but then from there, we would, see a notice of proposed rulemaking thereafter. And that's sort of a similar stage for the workplace violence and healthcare program or rule that's being worked on now. The interesting thing with that one, and I think Beeta's referenced this in her summary, but that was something that was actually pushed during the Obama administration, then got completely pushed to the back burner during the Trump administration. So now, it's coming forward again during the Biden administration, and that SBREFA process has recently been initiated. So again, sort of starting that process of involving small business and small business concerns before they get to the point of actually issuing a notice of proposed rulemaking. And then one other one that we thought would be helpful to just touch on briefly during this discussion today is a notice of proposed rulemaking for the worker walkaround representative designation process. So this one's a little different because that was actually something during the Obama administration that was more of a guidance document. Again, sort of went away during the Trump administration, I believe was pulled back, and now is being worked on in a rule form. So OSHA is classifying this as sort of an opportunity for clarification on a policy that they believe is something that is, I think, rightfully in place already, but they are going through the rulemaking process. So I think that's an important thing to keep in mind from an employer perspective. And the expectation is that the notice of proposed rulemaking on that will be expected this month as well. So some of the top things that we're seeing the most, current movement on, but we'll touch on several other rules as well, as Beeta mentioned, and really get into the specifics in the webinar on the 18th.
Yeah, that's great. Well, thank you again for joining today with the OSHA Quick Takes and giving the overview. We'll have a link below so people can sign up for the webinar on the 18th. Like I said, I know there's a lot of interest in following these new rules and making sure employers understand them. We'll have your link to your website and office numbers as well if people want to reach out and connect. As you guys know, most of our audience is primarily safety professionals. Should they be bringing others from their company to attend? Who would you suggest attend on the 18th?
I think that's a really good question. Also, I think it's really important for safety professionals to, kind of educate themselves, and we hope to be part of that process for your clientele. In addition to the safety professionals, the technical folks, if there's, in-house legal counsel, these are rulemakings, right? So every rule that we talked about today is about some hazard, some identified hazard. Even the worker walk-around inspection rule relates to hazards at the workplace. The safety professionals are the ones who understand, who analyze and evaluate the hazards. The lawyers are the ones who deal with issues like enforcement actions if there's a alleged violation of the rule, and actually maybe want to provide some policy perspective to the agency during the rulemaking process. So if there's in-house counsel, certainly, I think it would be, I'm hoping we're going to try to make it very helpful, interesting. I don't know if it'll be riveting, but it'll at least be interesting, and hopefully helpful to both legal professionals as well as health and safety folks.
Great. Well, thanks, Lindsay, Beeta, and Kate for joining us today. Like I said, we'll have the links below for the webinar on the 18th. Definitely encourage everybody to sign up and attend, and look for our next month's OSHA Quick Take when it comes down the pipe as well.
Excellent. Thank you very much, Scott.
Thank you.
Thank you, Scott.